the amendment bill has a proviso that says that the salaries, allowances and other conditions of service of the Chief Information Commissioner or the Information Commissioners shall not be varied to their disadvantage after their appointment. Is that not an adequate safeguard against some of the concerns that you've raised?
But suppose they did it at the beginning of an appointment. Let's say, for example, you're the troublesome commissioner. You were appointed by a hostile state government for a 3-year term, for argument's sake. Or rather, when you were appointed, the central government decided 3-year term was enough for you and not 5. At the end of your 3 years, the state government wants to appoint you again. Suppose the central government says, fine, we can't tell you not to appoint this person, but we've decided that her salary will be 1 rupee a year. I mean, you tell me what you're going to do about it. The law permits them to do that if they wish. Now, it so happens the individual is suffering a disability that is at variance with their previous pay, but this is technically a fresh appointment because the previous appointment finished after 3 years. You see my problem? The government central government should not have this power. What the original law, which by the way came after very detailed, intensive study and 3 reports of the Parliamentary Standing Committee, actually wanted to insulate the entire Information Commission and the commissioners from untoward government pressure. And that's why they said your salaries will be pegged to that of the Supreme Court and your tenure will be fixed 5 years subject to a retirement age of 65. And again, all your conditions of service will match those of the Supreme Court and the Election Commission. Now, this came about because the Parliamentary Standing Committee, which had every party on it, were very conscious that we don't know who's going to be in power next time. We want something which will not just be a handmaiden to the government. And it's interesting to note, this is one of those few laws that passed unanimously. There was not even a voice vote. Both houses loved the law and passed it without debate, without a dissenting vote. So it came about after very detailed examination. This particular law, this amendment, has not been submitted to the scrutiny of a Parliamentary Standing Committee because the government in its wisdom has allowed an entire session to go by without constituting any Parliamentary Standing Committees. So we're in the bizarre situation where bill after bill is being rushed through the House without any prior scrutiny by a standing committee. In the case of this bill, there was actually a requirement to post the bill on the website and get public comments, because there is also, by the way, from 2014, a pre-legislative consultation policy which requires the government to consult interested parties, including civil society, NGOs and experts. All of that has been bypassed in this unseemly headlong rush. Why? Because then you perfectly well know parliamentary committee worth its salt would within 5 minutes have tolerated allowing such a bill to come to the floor without some very serious adverse comment. Now, I just think that this government is deliberately delaying the setting up of the standing committees and then, I'm sorry to say, taking advantage of their absence to directly railroad through the Lok Sabha bill after bill after bill. Fortunately, the Rajya Sabha will still have another look at this, and I hope they will take a very long and hard look and disagree with allowing this to pass.